Fingerprints are unconstitutional in Michigan. Bet you didn't know that. Welcome to the Law and Life. I'm your lawyer, Patrick McGeehan, and I am your best friend at your worst time. Had a really interesting case come across the ever-expansive Law and Life newswire. Actually, it's from a listserv that I subscribe to, but it attracted my attention. One, because it's from Michigan, and I don't see too many Michigan cases. This case is from the Michigan Supreme Court. And number two, it involves Fourth Amendment search and seizure law. Search and seizure law is a very large and expansive area of law. There's all kinds of law from the Supreme Court to the appellate courts to the different states, and it's very, very interesting. It's usually very fact intensive, and I always like to read those cases. They're always good cases. Anyway, a little bit of background on this case. This case is actually two cases together. It's Johnson versus Vanderhooy and Harrison versus Vanderhooy. It's out of Grand Rapids, Michigan. So, Grand Rapids, Michigan Police Department had a program where they would do field interviews, or FIs, and they would photograph and fingerprint people even when they weren't charged with a crime. And if you don't know what an FI or a field interrogation or a field interview is, it's when an officer gathers information about a person they meet on the street. They may not arrest them, but they're just gathering information, such as their name, address, date of birth, and they'll note on a little card and then put it in the computer that information along with what they were wearing, different characteristics about the person. And police departments use that for an investigative tool. The way they use it for an investigative tool is, let's say that there's a crime. Let's say there's a burglary occurring in a certain area. The detectives will go back and they'll look through the field interview cards or the field interview information on the computer and see who's been FI'd in that area, field interrogated in that area. They'll get those names, they'll look into the background. Do any of these people have a background for burglary? Any previous arrests for burglary? And they'll develop a list of subjects, and they'll go through and they'll look and see which subjects fit the crime, any of them match the description, and they use it as an investigative tool. But Grand Rapids Police Department took it a step further. They did photographs and took fingerprints of people they just contacted, not charged with a crime. So anyway, the ACLU brought this case on the behalf of Harrison and Johnson against Vanderhooy. So who are Harrison and Johnson? Well, we have Denisio Johnson, who was a black male teenager. He was stopped in 2011 in a parking lot when somebody complained to the Grand Rapids Police Department that he was looking inside vehicles. He was photographed and fingerprinted by the police and released without being charged. Vanderhooy is a captain at the Grand Rapids Police Department, and apparently he is in charge of this program where they take fingerprints and photograph people. So he was involved with another officer in fingerprinting and photographing Johnson. Harrison is Kenyon Harrison. In 2012, Kenyon, he's another young black male, and I think these guys are like 14 and 15. And you know, kids that young don't carry ID. I didn't carry ID. I didn't carry ID until I had a driver's license. So they're not going to have ID. Anyway, in 2012, Harrison was stopped because somebody saw him hand another kid a model train or a fire engine, and it looked suspicious. So an officer came out and followed up and began speaking to him. He then took his fingerprints and photograph for this particular program. So anyway, then the ACL filed suit on behalf of these guys. Both of them were released and not charged with a crime. So then, you know, you go in and you look at how the program is applied. And the information I got from this program is how it's applied is there was a claim by the ACLU that the Grand Rapids Police Department targeted black people with the photograph and fingerprint program. 75% of the people who were stopped and fingerprinted and photographed were black, and 15% were white. And then in Grand Rapids, 58% of the residents are white and about 18% are black. So it's being applied to black citizens more than it is to white citizens. And the department discontinued, I guess because they were getting so much grief, they discontinued the program in December of 2015. So it goes through and it comes to the Supreme Court under the 1981 and 1983 actions. And under the Fourth Amendment guarantees your right to be secure in your person, your house, your papers, your effects. It secures all that against unreasonable searches without warrants. And all searches without warrants are presumed to be unconstitutional unless an exception applies. And they determine that taking fingerprints, because somebody has to grab your hand, stick it in ink, roll it on a card for all 10 fingers, and then sometimes they take palm prints. So it's an intrusion. It's grabbing your hand and putting it on this ink and paper and taking your fingerprints. And they look at searches, especially searches of persons, as how much is the government intruding, and to what degree does that balance against the person's expectation of privacy. Well, in this case it doesn't. That's why it is unconstitutional. So these people are being stopped. In some cases they're being detained on the scene while other officers come with the equipment to fingerprint and photograph. So they're being detained longer than what is needed just to conduct like a Terry stop. And it's going well beyond the Terry stop by the information and the facts that we have in this particular case. And it's already been previously determined in a Supreme Court case, I think it was Jones, that taking of fingerprints does constitute a search. And the court goes on to explain that the taking of fingerprints of a person in the plaintiff's case constituted a physical trespass onto the person's body in a constitutionally protected area, which is their body. And the act of fingerprinting is done to obtain information to confirm the plaintiff's identity. Accordingly, fingerprinting pursuant to the policy constituted a search under the Fourth Amendment. Now, if they have a warrant to take fingerprints, they're fine, but you just can't go around fingerprinting everybody for the sake of fingerprinting, for gathering information and putting it in a database or whatever. So you have a right to be secure in your body, just like they can't go around sticking needles in you to get blood samples without a warrant or applying one of the exceptions. And in this case, there's no exception that applies that allows the police just to come up to you and start fingerprinting you unless they're arresting you. Now, if they're arresting you, they can photograph and fingerprint you, no problem, because now you're in custody and they don't need a warrant for it. But for example, if they wanted to take a blood sample from you, if they developed information that you were a suspect in a crime and they wanted to take a blood sample from you for DNA or for whatever purposes, they would have to get a warrant for that, unless you consented to it. Now, you can consent in cases, you can consent to any type of search and they don't need a warrant. Once you consent to it, that's fine. But in this case, you need a warrant to take fingerprints. As always, thanks for joining us here at The Law and Life. I appreciate every time you step in and spend a few minutes, listen to me ramble about stuff that I enjoy, especially when it's Fourth Amendment stuff, and that's a great area of subject matter, conversation, or whatever you want to call it. If you like this type of content, please like and subscribe, share with your friends, and join us next time on The Law and Life.